Hello students, today we are going to discuss a very interesting topic which is the product liability under Drugs and Cosmetics Act of 1940. The scheme for the discussion of today's lecture is as under. We will start with the introduction, then jurisprudential inferences of the product liability, the liability in the cases of drugs and cosmetics, the authorities responsible to ensure the applicability, regulations governing the production, distribution and retail of cosmetics and pharmaceuticals, procedure to ascertain the sampling and quality check of the drugs, the latest developments on the issue, judicial interpretations followed by the conclusion. Now, let us start with the introduction to product liability under law of torts. Torts are civil wrongs that extend beyond the simple breaches of contract or trust. Unliquidated damages are the primary remedy under tort law. Common law principles dictate that negligence claims may be initiated when it is possible to establish that a duty to exercise reasonable care was breached, leading to an injury or due to said breach. In the event of defective merchandise, claims were made against the traders and the manufacturer because the trader was liable for the defect. The Consumer Protection Act 2019 defines product liability as the obligation of a product manufacturer or seller to compensate a consumer for any harm caused to the consumer as a result of a defective product being manufactured or sold, or any inadequacy in services associated with it. Alongside consumer protection legislation, the legal framework regulating product liability in India comprises several sector-specific and general laws. Depending on the sector and the particulars of the case, these laws may occasionally intersect. The following substantive civil laws are applicable to product liability: Bureau of Indian Standards Act 2016, the Sale of Goods Act 1930 and the Indian Contract Act 1872. The principles of product liability pertaining to selling or supplying defective products to consumers are codified under CPA, that is Consumer Protection Act 2019. For any harm caused to a consumer in the following circumstances, a product liability action may be brought against the product manufacturer, product seller or product service provider before the consumer commissions instituted under the Consumer Protection Act 2019. The supplied products are found to be defective, the consumer has been subjected to extensive pricing for the products, a trader offers products that are hazardous to life and safety despite being aware of their hazardous nature and in violation of prescribed standards, and the trader engages in any unfair or restrictive trade practices. Redress under the Consumer Protection Act 2019 is restricted to aggrieved parties who meet the criteria of a consumer as defined under Consumer Protection Act 2019. This definition excludes purchases for resale or commercial purposes and encompasses only individuals who have hired or purchased products or services in exchange for compensation. In the absence of meeting the criteria of consumer as defined in the CPA 2019, a wrongfully affected party would be obligated to pursue alternative avenues of redress, such as initiating a civil lawsuit alleging tortious or contractual liability. Now, let us discuss jurisprudential inferences of product liability. Caveat venditor, which translates to let the seller beware, in common law is the foundation of product liability laws. According to this theory, the seller is liable for any harm the consumer incurs due to the product or service he offers for sale. Therefore, the manufacturer and any other parties involved are obligated to compensate the purchaser who has been injured due to purchasing a defective or hazardous product. In recent years, through amendments and judicial interpretations, product liability laws in India have developed into a potent instrument falling within the purview of consumer protection laws. This legislation serves to safeguard the interests of consumers and promote socio-economic justice. The product liability legislation in India was initially interpreted restrictively by the Indian courts. In recent years, however, the judiciary has embraced a consumer-centric perspective. In product liability cases, a shift has occurred in which courts prefer to award punitive damages over compensatory ones. Specific legislative measures safeguard the interest of consumers concerning defective products. Product liability encompasses both criminal and civil responsibilities. Consisting of strict liability and negligence, civil product liability is a subset of personal injury law that pertains to the conception, production, distribution and sale of services and products. This claim may be brought against one or more businesses and corporations, including manufacturers, retailers and marketers. Furthermore, under the provisions of warranty in contract law, the product liability may arise. Criminal product liability occurs when the parties involved neglect to adhere to the stipulations of specific legislation intended to safeguard the interests of the consumer concerning various products. Concurrently, pursuing a claim under civil law and such criminal action is permissible under the Indian Penal Code of 1860. Now, let us discuss the liability in the cases of drugs and cosmetics, the authorities responsible to ensure applicability. The liability is ascertained under the Drugs and Cosmetics Act of 1940. Under this Act, the Drug Consultative Committee, the Drugs Technical Advisory Board and the Central Drugs Laboratory are indispensable to the administration. In addition to advising the central and the state governments on technical issues about the administration of the Act, the board carries out any other duties that this Act designates. A director appointed by the central government oversees the Central Drugs Laboratory under the responsibilities assigned to it by this Act or any regulations promulgated under the Drugs and the Cosmetics Act of 1940. Students, it is the responsibility of the board to ensure that pharmaceuticals and cosmetics adhere to the criteria outlined in the second schedule and that they conform to the standards that have been prescribed. The Central Drugs Laboratory must ensure that the cosmetics and drugs intended for internal and external use are effective, secure and not misbranded. Additionally, the board is responsible for ensuring that pharmaceuticals are not adulterated with harmful substances or utilized in a way that could mislead or deceive. In summary, the Drugs Technical Advisory Board, Drug Consultative Committee and Central Drugs Laboratory are integral entities in enforcing the Act and overseeing cosmetics and pharmaceuticals. The Central Drugs Laboratory is responsible for ensuring the quality and safety of cosmetics and medications imported into India. The entity mentioned above assumes the duty of overseeing the importation process of cosmetics and pharmaceuticals, procuring licenses, governing the submission of samples for examination, testing or analysis and furnishing substantiation for the quality of the substances or products that are being imported. In addition, the Central Drugs Laboratory must prevent the entry of drugs and cosmetics that are hazardous to animals or humans into the country or contain ingredients in quantities that lack therapeutic justification. If it is necessary or reasonable to do so, the central government may prohibit the import of such medications or cosmetics via notification in the official gazette in the public interest. Students, the Central Drugs Laboratory is responsible for examining and testing cosmetics and drugs, ensuring their safety and preventing the import of substances unfit for human or animal consumption. Additionally, they possess the authority to oversee packaging of cosmetics and medications, including using packaging materials that directly interact with the products. Furthermore, the Central Drugs Laboratory has to ensure the quality and safety of cosmetics and medications imported into India. This includes ensuring the absence of harmful substance contamination in the drugs or cosmetics and using safe, environmentally friendly packaging materials during production. In conclusion, the Central Drugs Laboratory ensures the quality and safety of cosmetics and pharmaceuticals imported into India. Adherence to the Central Drugs Laboratory guidelines is crucial in guaranteeing the quality and safety of cosmetics and medications imported into India. And now we will discuss rules governing the production, distribution and retail of cosmetics and pharmaceuticals. This section delineates the regulations governing the production, distribution and retail of cosmetics and pharmaceuticals in India. The legislation mandates the inclusion of the recognized scientific terminology of a particular medication on the label or package of any imported, patented or proprietary product that contains said medication. Infractions about drugs or cosmetics encompass counterfeit drugs, adulterated drugs and cosmetics falling within the scope of clause EE of section 10. Contrary to section 10, importing cosmetics or drugs as defined in any rule promulgated under this chapter may lead to a maximum prison sentence of 3 years and a fine of 5,000 rupees. The offender who violates the notification provisions outlined in section 10A may be subject to a maximum prison sentence of 3 years or a fine of 5,000 rupees. An additional stipulation is confiscating cosmetics or narcotics obtained through the violations of section 13. Section 13 offences cannot be tried in courts of inferior standing than those of a metropolitan magistrate or a first class judicial magistrate of the first class. When it comes to cosmetics, the chapter discusses misbranded medication. These substances are altered in appearance or rendered to have a higher therapeutic value than they are through coloring, coating, powdering or polishing. Adulterated drugs are defined as those that comprise noxious, putrid or decomposed substances. Conversely, spurious drugs are those that are produced under the name of another drug, give the impression of being that drug or bear the name of another drug unless it is marked to indicate its true nature and distinction from the bogus drug. The law delineates the policies and limitations governing the production and distribution of specific pharmaceuticals and cosmetics. Misbranded cosmetics do not adhere to the prescribed labeling format, contain an unprescribed color or bear false or misleading statements. Moreover, counterfeit cosmetics are those that are produced under the name of another cosmetic, bear a resemblance to another cosmetic in a way that is likely to mislead or bear the name of another cosmetic unless it is clearly and conspicuously marked to indicate its true nature and absence of association with the other cosmetic. Students, additionally, the law forbids the production or distribution of specific pharmaceuticals and cosmetics unless authorized by a license issued under this chapter. This encompasses pharmaceutical products that are below standard quality, have been mislabeled, adulterated or counterfeit. Cosmetics, patents or proprietary medicines, drugs that make claims of preventing, curing or mitigating diseases or ailments, cosmetics containing substances that render them hazardous or unfit for use as directed, pharmaceutical products or cosmetics that violate the regulations outlined in this chapter or any rule promulgated thereunder, and the pharmaceutical products or cosmetics imported or manufactured in violation of regulations. Now, we will discuss the procedures to ascertain the sampling and quality check of drugs. The state government designates government analysts and inspectors respectively with the responsibility of supervising the implementation of these regulations. Additionally, the central government or a state government may appoint individuals with the prescribed qualifications to serve as inspectors for particular regions. A drug or cosmetic sample is divided into 4 portions and sealed by the inspector's procedure unless the individual from whom it is taken is intentionally absent. When collecting the sample from the drug or cosmetic manufacturing location, it is only required to be divided into 3 portions. The inspector may seize 3 to 4 portions of a small volume container containing the drug or cosmetic, provided each portion is appropriately marked and sealed. The inspector is obligated to return a portion of the sample to the individual from whom it was obtained while retaining the remainder. The remainder or the container ought to be submitted to the government analyst for examination or evaluation produced before the court prior to the commencement of proceedings and transmitted to the individual whose name, address and other pertinent information have been disclosed by section 18 subclause A. If an individual has a duly designated their intention to present evidence in opposition to a government analyst's report, the court retains the authority to direct the Central Drugs Laboratory to conduct a test or analysis of the sample presented before the magistrate. The laboratory shall conduct the test or analysis and provide a written report signed by the director of the Central Drugs Laboratory that shall serve as a conclusive proof of the stated facts. In the public's interest, the central government may prohibit the production, sale or distribution of the drugs or cosmetics that pose a risk to human or animal health, fail to deliver the therapeutic benefits claimed or purportedly offered, or pose other similar concerns. Students, the Indian Penal Code outlines penalties for substance adulteration, spuriousness and violation of provisions. Drug adulteration can result in severe penalties including life imprisonment, imprisonment for 5 years and fines of up to 10,000 rupees. Violators of section 26A who manufacture or distribute pharmaceutical or cosmetics face severe penalties including imprisonment for 3 years and fines of up to 5,000 rupees. Students, the Central Drugs Laboratory or government analyst may face penalties for using laboratory reports to promote cosmetics or drugs. Substances derived from Ayurveda, Siddha or Unani are exempt from the Act, but government departments are subject to the same regulations. Good faith actions are safeguarded against litigation, prosecution and other legal proceedings. Preventing liability for actions performed or intended to be performed by the Act. The Health and Family Welfare Ministry of the Union has issued a notification regarding the implementation of Drugs and Cosmetic Amendment Rules 2020. This regulation imposes responsibility of ensuring the quality and regulatory compliance of marketed drugs in the country on both the marketers and the manufacturers. Students, now let us discuss some latest developments on the issue. The Ministry of Union Health and Family Welfare has proposed changing the Drugs and the Cosmetic Amendment Rules 2020, which defines marketer as a person who adopts a drug manufactured by other manufacturer for marketing purposes. Rule 84D prohibits marketers from endorsing or appending their name to the drug label without an agreement specified in Rule 2. Rule 84E ensures marketers are accountable for drug quality and regulatory compliance. To prevent drug duplication, the recent amendment to the Drugs and Cosmetics Act prohibits pharmaceutical companies from marketing drugs manufactured by another pharmaceutical company under their company name by labeling the drugs. This will aid in the public's purchase of the authentic product and prevent severe adverse events that are commonly linked to drug duplication. Now, let us discuss some judicial interpretations. Questioning of proceedings in S. Athilakshmi versus State Representative by the Drug Inspector 2023 pertaining to the sale of pharmaceuticals, Rules 123 of the Drugs and Cosmetic Rules 1940 and Sections 18, 18A, 18C, 27 and 27B, Subclause 2 of the Drugs and Cosmetics Act 1940, the appellant, in her capacity as an associate professor and head of the dermatology department at a government medical college, was a registered medical practitioner. She conducted her medical practice at her premises individually and independently. A drug inspector inspected the premises and discovered medications in an inner room. The drugs inspector filed a complaint with the Court of Metropolitan Magistrate to prosecute the appellant under Section 32 of the Drugs and Cosmetics Act. Grants the drugs inspector the authority to prosecute individuals for offences related to the manufacture and sale of Ayurvedic drugs. Physichem Laboratories Private Limited and others are involved in an appeal against the Andhra Pradesh High Court's ruling that the drugs inspector lacked the authority to prosecute individuals for such offences. The Supreme Court held that the inspector is competent to initiate legal proceedings against the accused for any such violation. Medical oxygen IP and nitrous oxide IP are drugs under Section 3 Subclause B, Subclause 1 of the Drugs and Cosmetics Act 1940. Supreme Court in the case of Andhra Pradesh versus Messrs. Linde India Limited 2023 ruled that these gaseous substances are liable to be taxed as drugs under entry 88 of Schedule 5 of the Andhra Pradesh Value Added Tax Act 2005. The appeal lodged by the state of Andhra Pradesh against the High Court's ruling that these substances are taxable as pharmaceuticals under Schedule 4 of the Act was under consideration by the bench. Now, reaching the conclusion, we can conclude that the Act of 1940 has provided extensive means to ascertain product liability in the case of the marketing and manufacturing of drugs and cosmetics. The Union Health Ministry of India intends to propose the amendments to the Drugs and Cosmetics Act of 1940 to maintain country's status as a leading producer of pharmaceuticals. A centralized database of drugs will be incorporated into the new legislation, streamlining the oversight of drug manufacturing, distribution and sale in response to a spate of drug-related fatalities in United States, Gambia and Uzbekistan. This action was taken. The Jan Vishwas Act 2023 aims to decriminalize offences and promote trust-based governance. It substitutes the phrase liable to a penalty which may extend to 1 lakh rupees for punishable with a fine which may extend to 5,000 rupees in section 29 and fine which shall not be less than 5 lakh rupees for imprisonment which may extend to 2 years or with a fine not less than 10,000 rupees or with both in subsection 2 of section 30. The Act has not yet been implemented. The Union Health Ministry is nearing completion of amendments to the Drugs and Cosmetics Act of 1940. These amendments would potentially implement a more centralized drug manufacturing, sale and distribution licensing system. The objective is to prevent a limited number of companies from jeopardizing India's burgeoning reputation as a global pharmacy by disregarding quality standards or failing to adhere to good manufacturing practices, that is GMP. The amendments incorporate a centralized database of pharmaceuticals to facilitate nationwide surveillance. If executed, the proposal would enable pharmaceutical regulators to instantly access the credentials of all pharmaceutical companies and medications, whether they are newly approved or currently in use. A centralized database that would notify the national drug regulator of concerns expressed by a state drug regulator does not exist. With this, we come to the end of today's lecture. Thank you very much for the patience listening.